different ways. She could speak to her fear of Mr. Duffy, the credibility of him actually being an additional threat. There's all sorts of different issues that could have come up with regard to, and I understand, Your Honor, wanting to limit the scope of this, for Ms. Singh's protection here. And again, I'm happy to the in-camera review of the documents as well. They do come into a credibility issue. The relevance is broad, but the discovery that I'm seeking all could potentially lead to admissible evidence, which is we've kind of fallen into the relevance factor of what I'm looking for here.
And then number 7, the documents related to medical records, reports, psychological tests. What are you looking for there?
Again, we're going back to credibility issues.
8 is documents pertaining to citations, infractions, violations, arrests, allegations of criminal activity.
Background information to the extent that has she done anything fraudulent? Has she done misrepresented anything in the past?
And petitions, summons, complaints, tickets, arrest records, any sort of legal process of any kind that you've initiated or received in the past 5 years?
With regard to the potential vexatiousness of Ms. Ng's status on how she uses the courts and or other administrative processes.
All right. And so, Ms. Ng, Mr. Palmer has gone through the 9 requests on Exhibit 1, and I think I'll tell you up front that I will allow the protective order to the extent that you would produce any ordered materials to the court for review before relevant information was provided to respondent and his attorney, and probably some sort of limitation on redisclosure, I think would be appropriate as well. But I've read your objection to the request, and so is there anything more that you would like to say about it?
Well, of course, Your Honor. I extended the olive branch to Christopher Duffy's attorney, Chris Palmer, a few moments ago, saying, is there anything we need to know before we go into this hearing? Can you fill me in on what's possibly going on? He said he sent me a letter proposing a civil compromise of a no contact order.
Okay.
And I believe I can't understand exactly what the motivation is, but I believe that is because stalking and sexual crimes are serious, violent crimes that could bear some heavy weight on the record of the person who assaulted me, Christopher Duffy, his client, who rubbed his penis on my thigh, pinning my arms until they bruised.
We don't need to go through all the allegations. I'm quite familiar with what you've presented.
I apologize to you that I have been sitting on the fence with knowing how to deal with his overburdensome request for my telegrams, my MySpace, my calendars, my records, my parking tickets, etc. And I trust that the court can make a decision what is relevant. It seems that Mr. Palmer has a problem with the First Amendment.
I'm not going to, I don't want to go into comments that may be pending with the appeal on the bar complaint. What I want to talk about is your response. I mean, I'm prepared to direct you to produce certain things and give you a timeline because I've pretty much decided what I think might be relevant and what I think would not be. And so that's what I want to limit this hearing to.
Can I say something? The things that I think are relevant. I understand he's alleging that I may cherry pick evidence. What happened after the assault was I went into severe trauma. I relocated myself out of my safe and affordable housing. I took protection with my family in Seaside. I then completely debriefed my family, who didn't know how severe the assault was. I then proceeded to email the attacker. I believe I experienced a certain measure of Stockholm Syndrome. He has a lot of good qualities. Charming, possibly too charming, in fact. he has good qualities, and I respected very much his history of public service, and I felt that there was something he could tell me that explained his assault. Perhaps he has Asperger's, perhaps he was in a disassociated state, or marijuana use, or whatever. Or he was madly in love with me. I don't know why he pinned me down after I told him he was reminding me of other abusers. So I gave him opportunity, and those emails were dated in October. There was another one in December after a very fearful run-in. His boss induced him, I believe, to write me an apology letter. I have that printed out. I have a lot of the things with me now that you may seek in an in-camera session to produce evidence. I'm also I'm a big talker, and I'm not afraid to talk. I'm not afraid to give you URLs. I'm not afraid to disclose my Twitter account or anything like that. What I am afraid of is that this county is lacking serious sense of responsibility in terms of sexual assault and endangerment of disabled individuals.
So let me just say, there are a lot of other issues that I'm not going to be able to address.
Yeah, of course.
And so the options for this kind of hearing and protective order are pretty limited. Either the temporary order is continued or it's not. That may or may not address any of the things that you are talking about that happened around your petition to seek a temporary protective order. And so, again,
Your Honor, can I put something in the record? I was assaulted after I came out about being GLBT, and I have suffered immensely with the hate crime aspect of telling this man who was pawing his hands all over me that I identify as GLBT and do not welcome his advances to me. And I just wanted that in the record, that forceful outing of my sexual identity has been very invasive. My medical records, which I can disclose if you wish, that is very invasive. My crime victimization with previous assailants, I have willingly offered to you in that letter, but that has also been invasive. I think he might have done better to choose a female attorney, because I feel traumatized by a male attorney trying to further violate me and re-victimize me.
And so what I'm going to do is I'm going to order the production of certain things on the list. And so, and I can revise the list to indicate the timelines.
How about let's have everything? I can haul you every record I have, and I don't think that gives his client a right to attack me.
And so, what's your time frame for submitting it to the court?
I don't have money for a taxi fare. I would have to haul 2 desktop computers, a laptop, and about 2 Rubbermaid totes.
Let me just say, I'm not going to be able to receive your electronic documents. What I'm willing to look at would be printed material that could be copied.
Well, how about the record with the APS, Adult Protective Services? I put the subpoena forward for Liz Rathbun.
Well, and I think the discovery request is only for things that you have control over and you have access for. So I don't think the request requires you to go search for things that you don't have. Okay. And so would it be reasonable to, we have a hearing scheduled for continuation of the protective order on July 19th. I'm thinking that that's going to be kind of difficult.
It might be with respect to the review of discovery in camera.
To look at it. And so I'm thinking, could we use a deadline, Ms. Ang, of maybe 2 weeks from now, say July, have the production to the court by July 12th, and then I'll try to get the review and materials to respondent, and then maybe we reset our hearing so that we set our hearing. It'll give you a chance to consider any options for settlement.
Settlement? Are you encouraging me that way?
I'm not. I'm just saying that I always encourage people to settle if they can, just because
I've been trying to for 2 years.
Because people walk away maybe not completely satisfied with the result, but they have control over what the result is.
If I may, Your Honor, Ms. Eng just indicated that she's attempted to settle for the last 2 years. I'm open to hearing what those settlement offers are.
And so that might be an option. I'm not really in a, we're not going to be able to have a settlement conference today, but I would encourage you both to maybe continue that effort in writing, or if you want a judicial settlement, we could see if we have resources available. But so today was to talk about the motion to compel, which I'm going to grant. In part, I think it's reasonable to do some limitations, but Ms. Eng, you've indicated you're willing to produce everything.
I'm willing to share everything I have.
Okay, and so could you provide that to the court? Is 2 weeks enough time?
I have a file I can hand you today
Okay.
with some basics. I have an evidentiary question. When I have the adult protection of his confession of initiating wrestling and tussling against me, which is his euphemism for sexual assault, I tried to enter it in evidence in my ex parte hearing. You gave it back to me. The Oregon Law Center has advised me that it could be a hearsay rule type of a thing. And so that is why I've put forward the subpoena for Liz Rathbone for the 19th hearing, because she is the one who recorded that evidence during the criminal questioning. And I feel that that's very self-incriminating, as well as his emails indicating that he knows he made me feel unsafe.
I'm not sure
those
what
are
to say.
available to you, and I would like to continue to offer them to you, but I'm not a lawyer, so I don't know the rules of evidence.
So what I'm going to do is receive the documents that you think are responding to the request for discovery. And so I don't want to necessarily receive them piecemeal. I want to be able to receive them sort of intact so that I can review them, keep them intact, provide copies of what...
I give them to you?
Correct. You would, or bring them up to the court window and say this is the discovery requested by Judge Matyas for an in-camera review. And then someone would notify that Ms. Eng brought a box or 2 boxes or whatever of these materials. And then I'll look through them and decide what I believe is relevant to this stalking protective order, copy them, and provide them to Mr. Palmer.
Matyas, I have another question. When Christopher Duffy was trying to lay his hands on me, grope my breasts from the side, grab me around like this, I debriefed him on my grandfather's work in national security matters, and I do feel that the breach of my records puts me in danger, and that I want the breach to be discontinued. I've blogged very extensively on FBI matters. I feel that my whereabouts, it continues to be endangered by the threat posed to me by the man who almost killed me in 2016, who injured my neck. When Mr. Duffy assaulted me, he re-injured the whiplash and rib injuries. And I feel that I really want sensitivity to be taken with my data in respect to who I am, and the fact that I did not have to tell Mr. Duffy about my grandfather's work, except that his pushing me around made me feel that he doubted my intelligence or my sanity, as Mr. Palmer seeks to dispute or put my credibility on the line. And I'm an archivist of my family records. I'm a very open and transparent person, but I have traveled overseas, and I have blogged extensively on national security matters and international security matters.
You know, I'm not going to really, to be honest, be interested in history that goes way back, because I don't believe it's going to be relevant for the events that may or may not have occurred with you and Mr. Duffy. And so I guess what I'm saying is, if you produce that information to me, it may or may not have any relevance to these proceedings. And so if you're asking me to redact some of your personal information,